Ladies and gentlemen, my name is Khaitan and I am a partner in Khaitan and Company's corporate M&A practice group. Thank you for taking the time to be with us today. I'd like to extend a very warm welcome for this webinar to every one of you, whether you are in our audience in India or any other part of the world. This is the second webinar in our M&A Masters series over the course of 2021. And we look forward to your company throughout the series. I am very pleased to say that we've been thrilled with the tremendous response we've had to the M&A Masters series, with literally thousands of people taking up the invitation to register and attend, both from India and abroad. We are very grateful for the interest and support which our clients, associates, and others have shown in responding to the invitation. On this slide, you'll really see the agenda for today's events. In short, the format will be a discussion between the expert panel for approximately 1 hour, followed by a Q&A session with audience questions for approximately 15 minutes. We have already received several audience questions, and if you do have more questions, please do submit them using the facility provided in the webinar portal. If we cannot cover all questions during the webinar, we will respond offline by email after the webinar. Please also note that a copy of the presentation and the recording will be emailed to you after the webinar. In this second webinar, we are exploring how buyers should do M&A due diligence. We chose buyer due diligence as the theme for this second webinar because in every M&A deal, due diligence is absolutely fundamental to the deal. Due diligence can actually stop a deal, confirm, or totally reshape the transaction as the process moves forward, and can also mean in terms of indemnities and risks being allocated, which are material to the deal. Concluding a due diligence can be straightforward or very complex because it requires coordination, collaboration, careful planning, and meticulous execution by different teams, as well as so many other factors which we will discuss in today's webinar. As one of our panel members actually mentioned, that while preparing for this webinar, that due diligence can either be most boring or it can be most fascinating experience depending on the circumstances. Whether it is boring or fascinating is one of the most important components of the M&A process, if not the most important from the buyer's perspective. I should say at the outset that this webinar is focused only on the buy side and how a buyer should deal with due diligence in M&A, because we did not think we could really do justice to both the buy and sell sides. In my professional life so far, I have seen due diligence in India evolve from virtually a zero base to what in many cases today is a very sophisticated, complex, multidisciplinary investigation. I'll share my first example of M&A, and when I joined as a young M&A lawyer working with some of my senior partners, I still remember my first large deal was 175 crore public market acquisition, where the SPA was a page and a half, and there was absolutely no diligence. The only warranty on the SPA was clean title to shares, and there was zero due diligence. How that evolved as we kept moving along was some amount of diligence, but still for public companies, there was absolutely no insider issues, and you could freely do due diligence even in a public company. and it kept evolving from, say, loads and loads of physical data, and that's how diligence was done. I remember again, traveling to Orissa on a train to do due diligence at the factory site. Today, all of those days are gone, and we are doing digital diligence for sites all over the world. So that's how diligence has evolved. And just before we were starting this webinar, we were chatting that diligence in the COVID times is even happening through drones and through video recordings. So this brings me to our expert panel. Every person who has registered for this webinar today has already received an email with full particulars of the creds of our panel, so I'm not really repeating or summarizing them again. Suffice to say that they are all excellent M&A professionals with impeccable credentials. We are very fortunate to have with us 4 leading M&A practitioners on our panel. Abha Agarwal is an executive director and co-head consumer, FIG, and business services verticals of Avendus Capital based in Mumbai. Himanshu Dudeja is managing director and head of legal of Blackstone India based in Mumbai. Sharad Mishra is president, group strategy of TVS Group based in Singapore. Kuldeep Tikka is partner and national leader of the transaction diligence practice of EY in India based in Mumbai. In addition, we are joined by my fellow Khaitan & Co. corporate M&A partners Akash Chaube and Prasanjit Chakravarti, who are both very experienced M&A lawyers. So now let's begin our expert session. I'll start, by the session. I think you can take the slide off. I'll just start the session with, the basic topic of maybe definitions. And Abha, if I can start with you, how should we define buyer due diligence? And what are some of the common work streams and sector issues that arise?
Hi everyone. Thanks, Agreed. So I'll go see. Frankly, when we look at buyer diligence, there's no standard template for us, but depends on who it is. Whether the buyer is a financial sponsor or a strategic, actually is the first lever on which it is defined, and then next comes the whole timeline and process. So whether it's a bilateral discussion versus a call it a very tight auction process, again, kind of it creates nuances, but by and large, what we've seen is very commonly is the basic financial and tax diligence, where the historical financial and tax numbers are checked and investigated to form a view on the quality of books and accounts. And legal, these two I would say forms 99% of the deals would have it. Maybe 1%, like I was sharing with the panel before, deal closing in 2 weeks from term sheet probably may not have one of these, but that's probably 1%. Besides these two, what we have seen is very sector specific focus. So whether it's manufacturing, HSE becomes important. In education, fire safety and more safety related concerns become very important. In IT companies, IT analytics have gained more importance. Large people driven businesses, HR diligence has become something which people are focusing on. So some sector based, but more financial, legal, tax being very common. And yeah, one more area that we are seeing increasing these days is commercial diligence, and more so especially with financial sponsor groups, that we also see consultants being hired to answer some market sizing or business model questions about margin, price a customer would pay, and things like that. More and more also in tech and digital sectors, where these questions are anyways not answered at the moment, and things are at an evolving stage. Yeah, so those are the buckets. Again, some people stage it. Some buyers finish the ones which are necessary and a go-no-go decisions first, and some put it later. Another FCPA diligence we've seen not being done by everyone, but Some financial sponsors, it's very important for them, which is staged so that the process also can be managed well. So maybe they are done towards the end. But yeah, those would be the typical ones. In consumer, which I lead, we've also seen a lot of focus being placed on, again, market share, brand IP. So IP diligence becomes important if it's a brand related sector or a IP related sector. Yeah, so those are the ones I would think define normal diligence set.
Very interesting, Abha. Actually, it seems diligence is getting deeper and wider both as we see this evolving. So let's move to the nature of diligence. And Himanshu, if I may ask you, is buyer diligence in India much different from other parts of the world? And is diligence different for different buyers or types of deal? I think you'll be best, and I don't know what type to put you on because you do M&A of every type, but it'll be very interesting to hear from
Yeah, no, thank you, Hybrid. I'll say a couple of things. At least for financial sponsors, I would say the quality of diligence and the type of diligence pretty much remains the same, or the approach towards it. For instance, if Blackstone is doing a deal in Argentina, the lawyers and the professionals would wear the same hat as they would here would wear for a deal in India or any part of Asia. Having said that, can you say that a Indian conglomerate doing a deal outside India, will they wear the same hat as a financial sponsor? Maybe or maybe not, because the considerations could be very different. So I would say that bringing in the comparison in terms of how diligences are done in the US, Europe, and say Asia as a market on the other hand, I would note a couple of things. Number one, the format of diligence has changed or has evolved quite a lot in those geographies. For instance, in the US and Europe, we spend a lot of time upfront. What is the key growth driver? What matters the most to the business? What are the 10 items that we care about, rather than the laundry list of everything and anything that comes with it? As you rightly said, whenever you did your first deal, diligence was never a recognized concept in India. You just had a 1.5-pager SPA. From those days, India has come to another extreme where a diligence report will never be less than 1,000 pages. Of course, it helps the lawyer's cause in a very significant way, if I may put it that way. But having a very user-friendly diligence, I think, is the key, which everybody understands in the US and in Europe. Something that we are focusing on and we are working towards, and I think in India as well, you would see that right balance in terms of what to look at and what perhaps not to look at. So that's point number one. Point number two, the kind of issues that you face in the US and Europe and the stuff you see in Asia or in India are very different again. There, as we all know, the disclosure norms are very strict. The quality of disclosure is very, very high. Whereas if you compare the disclosure norms to India, if you're looking at a large public listed company, very difficult to really see what's going on unless you do a very thorough diligence. So again, you wear a very different hat when you're looking at deals in India. The kind of issues that you really focus on, whether it's FCPA, Abha talked about. FCPA is a very, very big theme for large financial sponsors. ESG, another one. This is where a strategic in India may have a slightly different view on certain things, whereas a large financial sponsor having operations all across the world would see such things very differently. Having said that, Indian lawyers' job, I would say, is the most difficult one in the world, because there is no deal that exists out there where there is no real noise around things, whether it's FCPA, whether it's CBI, ED, and the concept of a promoter, all of that. These are so unique to Indian geography Therefore, you have to really apply a very different lens to some of these items that when you do diligence in India. So that's the starting point. The second thing I would say is that it very well sort of depends on the kind of deal you're doing. Very important to appreciate that upfront. Are you doing a minority deal? Are you doing a control deal? Are you doing a structured slash, say, a stress deal? Because in a minority deal, you do the diligence, but largely the interests are aligned. You're a 20% shareholder, 80% shareholder is on the other side. If there is a problem, everybody lose money. So it's, in some way, the interest is aligned. You can think in that fashion. Whereas if you do a control deal, forget about indemnities, forget about reps and warranties. You have to live with it. You are the sole sponsor for it, so you have to really manage that. You have to think very differently. That is the problem even solvable? Forget about whether you have protection for it. Is the problem going to go away, or will it stick with you for the rest of your life? When you're doing a structured deal, all you care for is that will you actually get your money back? Is there a key man risk? Is there a business disruption risk? If you have things like non-compliance and a bunch of other things, it doesn't matter as much in a structured deal, right? So again, very important to really see the kind of deal you're doing, and accordingly really work on your scope of diligence. You identify the areas and apply the threshold to it. And as I said, lastly, very important to really start focusing on items that can drive the business or can affect the business. The rest of the stuff, I think it's become commoditized in terms of whether ROC filings are there, not there, or regular audit notices are there or not there. But eventually, I think where people like Kuldeep and some of the other professionals play a very important role is to really help the business do the business in a right way and in a value protected sort of environment rather than just a legally compliant environment. So why don't I pause there, Haipreet?
That's really insightful, Himanshu. Really gives a very, very good perspective. Uh, and that really gets me, to this question on the whole purpose of diligence. And, it takes to the question, why are we really doing diligence? And maybe Sharad, your best place to answer this, being a serial buyer of businesses and investing in businesses, as you've been doing for the last couple of years. If I may ask you, what's the purpose of buyer diligence, and how do you really link the purpose with what is done in the diligence? Um, are you on mute, Sharat, I think?
Apologies. Can you hear me now?
Yes, we can hear you.
My apologies. So I was saying, first of all, thank you for having me. I agree. When Himanshu's comment actually more or less, was summarizing the purpose also. Fundamentally, for me, any M&A activity should not be thought and done one-off activity in a company, especially the one which is done in scale. And it should have been a part of larger strategy game, actually speaking, at least mid to long-term strategy. So you clearly know why you are doing it and how it fits to the overall, a purpose of this. So if you see the diligence from that point, I think it become much more clearer and easy. And also what Himanshu was mentioning about not having a laundry list of everything, but making sure that there are specific things which you need to look very, very deeply, which are no-go many time, and something which are specifically good to have, and some information is just for information. So that's where you can make the whole process efficient. So if I can say, overall purpose of any buyer diligence is basically to assess the benefits and the liabilities of a proposed investment, which is a common sense. But more important, by evaluating all the aspect of the past, present, and future of the business. And I will highlight this future part a bit more. And this is where I believe the business happen, because when we do diligence, we look into past and present quite strongly, and future is very vaguely defined, or defined from a way of how the seller see it. I think we should have a very strong buyer should have a very strong perspective of that, not from the purpose of negotiation only, but also try to see from a fitment purpose. And if you list down the detailed purpose of it, one is definitely the risk association with the transaction should not outweigh the potential benefit. The second, in my mind, will be to see the accuracy of valuation, build a reliable and predictable financial models. I can also see it identifying the issues that need to be addressed, especially during the definitive agreement time, because there are some closed, not closed matters which need to be seen in practicalities. That is especially like warranties and indemnity, etc. And I'm pretty sure lawyers help quite a bit there. The fourth aspect from my viewpoint is the which is very critical, is the plan for integration and value of plan, and you identify the responsible team who's going to be integrating. It sounds a bit too early for doing that, but I believe that when you are doing diligence, that also need to be kept in mind, because eventually the whole purpose is to make a successful result of this whole acquisition or any acquisition. So this value of plan is an integration plan is extremely critical, and I have seen personally that how deal fails is post deal fails because of majority time HR issues and cultural aspects also. And the fifth part, which is also very critical, is the communication plan for different stakeholders, including vendors, your customers, employers, and investors. So from my viewpoint, this is a purpose. And if you have to link this one, there are many examples, right? You can always talk about critical, if you're looking for numbers, look into macroeconomic trend, look into the industry you are investing in and other things. But I think it should be, again, going with what is the purpose of your acquisition. If you're doing a acqui-hire, so your main purpose should be on management team and the key member of the team, and identify the agreement, what they have in the past, how they have been going to be retained in the system. That will be defining your like a main points of the diligence. But if you are doing it for scaling your product, you should be doing to build management KPIs where part of the transaction value payout is linked to the product launch and scale milestone and other things. So again, just to summarize, in my viewpoint, while going with the on the detailed activity part of it, but I will restate what Himanshu highlighted, that how to make this more efficient and more purposeful will be more important from a buyer perspective on diligence. I will take a pause here.
I think, Sharad, that's been immensely useful, because many a time when sort of clients come to us for diligence, they just say, do the diligence, complete it in a week, complete it in 2 weeks. And the whole purpose why you're doing diligence and the way you articulate it, that it's not just about assets and liabilities, but there's so many other purposes to be accomplished out of diligence. And that, I think, is immensely useful. So I'll move on to the next sort of section, and that is due diligence team. So over to you, Akash. As a leading sort of lawyer, leading so many M&A transactions, can you really give us some insight on who should be on the buyer's due diligence team?
Sure, I agree. I'll maybe make an attempt, perhaps through just walking the audience through how a typical call comes to a law firm office. And a typical call to a law firm office, is the client calls to say, "Hey, Akash," or the relevant team, we're looking at this acquisition. Too many pools of capital chasing this particular asset. There is people like Abba who's prepped up the company. You have a great vendor diligence report from a reputable law firm. You have very limited time, quick fire, 2-week, 3-week, 4-week process to run a diligence. And typically, what would you also get advised, and rightly so, with the way transactions are getting more sophisticated, is optics become very important. What questions you ask, how you ask them, how many people are manned on the project, how do you behave in the manner where the similar pool of capitals are chasing. So all of the softer side and the hard diligence side are all together. So you get a very clear kind of instruction on what is your movement around, and asking the right questions and minimal questions. Of course, not to cut corners. You run, you put together a team, and I'll come to your question in a minute, Agreed. And you do the transaction, and after the transaction, and hopefully it has not happened much, but you get the similar call. New discovery happens, and you've walked a very tightrope, and question comes to say that, okay, there's a new discovery and finding is not there. What happened? Did the advisors didn't pick up? Was it something which was hiding somewhere? How do you really manage? So I would say the answer to your question lies in between, where you tread very carefully and you have the right set of people who look at exactly what they need to look at. So I would say, in terms of leaving aside what the kind of teams you will have, you should need to have focus on the right people who, one, should be expert in this on the subject, quick on uptake. You can't have a kitchen sink approach anymore to diligences. Like Himanshu was mentioning, 1,000 pages, you can't today dump a long requisition list to a target. You have to be very careful on how you approach it. And in terms of people, I would say that typically a transaction starts from the commercial teams to begin with. In Indian context, I agree with what at least, and please, please share others if you think otherwise. But the whole ethical FCPA, political connection, nexus, background check, I think is the first gating item at a high level. Of course, confirmatory works get done. So you get all of them getting done. When you say that, okay, commercially it's making sense, and I have a counterparty where I'm willing to take the risk, that's time you get into more detail, get a tax, financial, legal, accounting diligence kicked off. And lastly, I would say, depending on sector, you have a real estate sector, then you will get surveyors, you will get architects to look at all those specific provisions and specific aspect covered on. So I would say that's broadly the team. But in summary, I would say that diligence is perhaps a very mundane process, but you can't really cut corners. It's like, evidence is picked up at this level. You can't go to Supreme Court and have a determination of question of law when the facts are not right. And diligence is the time you get your facts right.
Oh, fascinating. Actually, that really shows how fascinating diligence can be as compared to, that mundane and boring subject we all talk about. So let's talk about the diligence plan then. PC, how do you plan a buyer's diligence, and should you have a formal plan? What do you say?
Oh, yes, absolutely. I think a formal plan is an absolute must. I think it cannot be overstated. I think what a plan does is, first and foremost, lays out the objective, the commercial objective of doing the diligence, doing the transaction. And unless that is clear, it will be, like a bunch of headless chickens moving around. So we need a formal plan. That plan should be ideally, in my experience, devised by the management, somebody like Sharad, a core management team of the client or the buyer, in conjunction with discussions with the advisors. Because ultimately the advisors are not on the same page, whether in terms of timelines, execution, it will be not really very efficient. So plan helps to chalk out the objective. Then after the objective, who will do what? The allocation of roles and responsibilities should be delineated in the this plan. We don't want overlaps, isn't it? More often than not, we see a lot of overlaps. Advisor X is taking care of particular aspect, so is the advisor Y, and the reporting lines are all muddled up. So I think very critical to allocate responsibilities in the plan. And the plan should also set out some other technicalities and modalities. What would be the protocol to reach out to the target? I can give you a few examples where things were not that planned and were absolutely terrible. The seller was very, very conscious and very skeptical that they will not be sharing customer data upfront. This was not shared with the lawyers and some of the other members of the team. The lawyers mindlessly kept on sending requisition list asking for customer data, and that really sent a very wrong signal to the seller. Seller thought that the buyer did not really pay attention to what was told, whereas it was a case of classic miscommunication. This should be addressed in the plan. We should set out what kind of protocol should be followed, who should be communicating with whom. The next plan is, which the plan should set out, is what would be the timely catch-up calls required? Communication is often the key, which I just mentioned and gave a small illustration how communication can be fatal if it's wrong. And therefore set out weekly, bi-weekly communication with all the advisors, and not only internal but also external. Now, the other key facet in communication is shouting out the red flag issues. It's important to highlight an issue. Timing is often the key, because while all the diligence is going on, more often than not, parties are also having a discussion on the definitive agreements, and something which is fundamental issue, no point in holding it back in the back pocket. You should flag it up upfront, kick it up to the principal, so that that can actually have a substantial impact on how a deal is structured. I remember a transaction where parties were very much aligned to do a demerger, but however, the target had tons of lands, which made it completely suboptimal to do a demerger because of stamp duty implications. Thankfully, it was escalated early enough and the structure was altered into a shared deal. Now, if this was not brought up early enough, people started drafting demerger scheme, waste of time, waste of money, and really doesn't help anyone in the process. Very important to therefore timely communication, we should be having. All of this should be outlined in the plan itself. I would say agree. So plan, yes, absolutely must. It cannot be overstated in my view.
Oh, thank you, Prasanjit. I think as we move on our due diligence mandate, and we've sort of defined nature, we've got the purpose, we've got the team in place, we've got a plan in place. Now, let me ask you, Himanshu, that how do you identify, define, and use key business risks and opportunities to scope the diligence?
Yeah. Before I answer that, let me, on a lighter note, say that diligence exercise can only be fascinating if you have lawyers from Khaitan and Co. Right? So, and this is not a paid statement. Just to be very clear, this is on an arm's length basis. To answer your question, Higri, I would say, it's, as we were discussing right at the start of the call, doesn't matter what's written in your SPA, doesn't matter what's written in your merger scheme. What matters is, does the buyer know what it is doing and what exists out there? You can find a solution to a problem when you know what the problem is. Otherwise, it doesn't go anywhere. So I think from that perspective, diligence becomes the most important tool, because on the basis of diligence, you're deciding whether to lean forward or to step back on an asset, right? Therefore, it becomes very, very critical that the client takes the ownership to spend that extra time at the start of the diligence process. As Prasanjit was also saying, communication, communication, and communication. That's the only way for this success, because you would have tax diligence going on, you would have legal diligence going on, you would have FCPA diligence going on, you have business diligence going on, and many other diligences at the same time. Now, unless there is a real project manager who's putting all the dots together, there is bound to be some sort of something is going to fall through the cracks for sure, whether in terms of how you correspond with a counterparty, somebody thought somebody else was looking at a particular item, and so on and so forth. So very important at the outset for the client to spend time, a hell lot of time, with all the advisors, walking them through, not in terms of how the URL should look like, but walking them through what does the business entail, what are the risks that the business sees in a particular sector, whether it's real estate, whether you talk about financial sector, and make the lawyers and the other participants as partners to that assignment. Because Khaitan, let's say, is a lawyer, is a team which is working on the diligence. You're looking at a pharma sector, you're looking at financial sector. One cannot and should not have that view, or an ostrich view, that we know it all. So use lawyers not only to just tick the box, but use them as, or have them as, real business partners to find the real things that one should be aware of. That's a macro statement. To give you a sense, let's say, to your point, that how do you really define your scope? Let's say you talk about a mutual fund industry for a moment. right? Now you track the changes that have happened in the mutual fund industry, you would see anything and everything affects the business. It will be unwise for anybody to say, we don't have to really look at the diligence part or the past of it, because we are underwriting our model on the basis of what lies ahead. Whether you talk about pricing, SEBI came up one day and said, if you have AUM of more than $50 billion, 50 crores, there's so much of cost that you can or expense you can have, or kind of a revenue you can have out of it. Whereas if it is less than 50 crores, you think differently. Now that's archaic, but at the same time, regulator has the power and has exercised that power in the past to affect your business model, for instance, right? Point number one. Point number two, regulator has also sort of prescribed, whether you talk about PISARA, you talk about, again, financial sector, where how the commission-based scheme has to be worked out, whether it has to be front-loaded, back-loaded, can have a huge impact on the business. Again, how, even if you control the board, even if you control the company, but what are the restrictions at the board level, which affects the governance part of it? So first two topics were which affect the business in terms of what can you do at the board level, how many independent directors have to be there. Even a majority guy cannot actually have the majority on the board in a executive way. So that affects pretty much the day-to-day or how you really think about governance part of it. Then you go to the exit part of it. In mutual fund industry, the moment you say, okay, fine, I'm gonna have a controlling stake or whatever stake, more than 10% you require SEBI approval. More than 40% change of control you require. Again, a sponsor change requires SEBI approval. So pretty much you're talking about things that affect your value, things affect your governance, and things that affect, you've got to think about how you're going to play this out and really exit from the company, especially from a financial sponsor perspective. Now, all these things, you will have to have that view that you've got to diligence the item. You have to have a view how the regulator is viewing the industry, how the regulator is viewing the target, right? How are they thinking of foreign ownership in a sector like, say, real estate, financial sector, and many other sectors that we can talk about. So in short, very important to really see the precedents, the past. Future can only be determined if, I always say this, you've got to drive the car by looking at your rear mirror, right? You cannot say that I'm not going to look at the rear mirror, because that's not going to get you anything. And that's where your quality of diligence, level of participation, the quality of advisors make a huge difference in defining the scope and then implementing it through, so that you know what lies ahead for your investment. Let me pause there. Heidi.
A fantastic perspective, Himanshu. And I can only add there that, look, apart from the business purpose, the identifying risks and opportunities, it's a huge learning for a lawyer as well. And I can only share one experience where junior lawyers, when you tell them you're on this diligence, you can look at it, oh my God, another diligence, that's so boring. But another way to look at it is that you understand a completely new sector and business, because you have to not confine yourself just to that business, but perhaps the entire sector, and you become a sector expert for some way. So let me move to, if I should say, our master of diligences in India, and that's Kuldeep. If I should say, because Kuldeep, with your decades of experience, you would have diligenced every business, every sector. And if there is one person in the country we all look up to on diligence and sort of fact finding, it is you. So with that, really, how do you sensibly define the scope of a buyer's diligence and ensure that it is efficient and cost effective? Because diligence can be a minefield. So how do you really do that?
Yeah. Thanks, Hagreev. Good afternoon, everyone. Thank you for this opportunity, Hagreev and Khaitan. Look, essentially from a scoping perspective, diligence scope is the most important thing that you would do before you actually hit the ground running in terms of starting the diligence. So it becomes a very, very important factor, a matter to look at or to focus on. When we look at scoping our diligences, we basically look at three key things. Every deal has got certain key questions that a client is looking to answer for. So I think the first thing from at the time when you're looking at scoping is that what is the client focus area? What is the client is looking at to achieve out of this deal? Just to give an example, client may be very interested in understanding whether it's a 15% EBITDA business or a 19% EBITDA business. 19% is something which is shown in the business model, 15% is shown in the historical. So you have to bridge the gap to give comfort to the client as part of your scope of work, that whether it is a 15% or 19%. So that becomes, so basically you have to understand what the key question is in the client mind is and try and address that through your scope of work. Similarly, if you're looking at a financial services company, adjusted net worth is the key thing that the client is looking at. Now, what are the various things that could impact the net worth, reported net worth of the client? So you put that in the scope of work and you focus on that. So that's the first set of questions that the client may have. The second set of questions the client may have is that what is the normative working capital in this business, especially if the business is a seasonal business. So you make sure that you cover that aspect as part of your scope of work. And at the time when you do diligence, you give specific focus in understanding what the normative working capital of the business is. Similarly, growth. Typically in expensive deals, we find growth becomes a very, very important question for the client. This business has grown about 20-22%. That's the reason why the deal is so expensive. Whether it will continue to grow at 20% or no. So again, diligence should address that aspect. So first thing, key questions that the client has in the mind, that is something to be addressed as part of the scope of work. The second thing is, what are the big risks that you see in the business? Those risks could be in the form of, let's say, reliance on a particular customer. Let's say if you're doing a diligence on a commercial real estate, the first thing that you have to look for is that which are the industries in which the client is operating in, and what is the nature of client. Let's say what's the nature of the client, the size of the client, the profitability of the client, of your tenant as such. So you have to form a view on the sustainability of that particular client being your tenant over the course of, let's say, next 7 years, till for which you'll have the investment. So forming a view, so that is a big risk. Sustainability of a client or a customer churn is a big risk in any diligence that you do. Second big risk that one can think about is any taxation related risk, direct tax and indirect tax, both. We know there are plethora, so that's something that you have to watch out for, cover that. Legal risk, something that you have to cover for. So the second area which you really need to scope very well is the risk area. What could be the big risk that you're looking at the business? How do you address that? And the third risk that I would refer to is something that Himanshu mentioned earlier on, is Sharad, that at the time when you're doing a deal, it's not about getting the deal done, but what is it that you need to do after the deal is completed, which is in terms of the entire transition plan. So diligence is actually the best time when you can understand the business much better than anybody else can. So you can identify the issues where there are synergies, where there could be certain outside support that may be required post-investment. So you have to think about matters such as what could be the separation issues, what is it that you need to include in your TSA, all those things. So that's another scoping item, especially if it is a majority deal. So that's how I'd look at scoping a diligence work. One is key questions, and my report should answer. It should not be a 100-page report. My report should answer only those 5 questions that the client has. That's it. The client is not interested in the 6th one. The key questions, the big risk, and then finally the matters that could impact the client post the deal. Those are the 3 broad buckets in which I would put my scope. And I agree, just to pick up your point, diligence to me is the best way. It's not boring at all. It's the best way to understand and learn a business. So today, if a fresh chartered accountant comes in and passes out, the one thing that we tell him, the thing that you need to do first in your this thing after articleship, after passing CA, is do diligence for 3 years. That will give you the ability to understand business, analyze business, and then you can then chart out your career as an investment banker or a private equity guy. So yeah, it's a very, very big stepping stone for young professionals.
Absolutely. I mean, I sit on this side of the table, but if I was ever to sit on that side of the table, the first thing I would do is ask who is leading my diligence team, and ask the professional, because I think that is the most important person in the M&A transaction, whoever is leading that DD team. So let's move on. Let's discuss some common mistakes which buyers make in scoping diligence and why those mistakes have occurred. So Akash, can you share some of your thoughts on this?
Sure, I agree. I would maybe start off by perhaps a more generic statement that, see, the transaction world is quite evolved. Today, either you have, likes of Sharad who are, acquiring businesses one after the other, or you have financial sponsors that cover a lot of the M&A activities like Himanshu and number of financial sponsors across asset classes. So they're sort of the routine buyers of business, and they understand the process well. They know how to prioritize, what question to ask. I think where the common mistakes come and where some issues come about are the human side of it. So some, and I'm not going to dwell on it, but some of the human issues are you're not connecting the advisors enough. You're not making sure there's a routine calls. Tax guy saying something, legal guy saying something else. You have accounting and things slipping through the cracks, as Himanshu would put it. So those are the one or two general statements that people make. I think two other sort of mistakes which buyer end up doing it or not preparedness is one is who's the consumer of your diligence process. So on most of the transactions now, especially the mid to large scale transactions, they're leverage back transactions. So the buyer is not only putting its own equity capital, it is also getting its LP to invest, or it is taking a financing offshore or domestic. And the risk assessment of the provider of the financing could be very different from the buyer himself or herself. So first, I think, is analyzing where the asset pool will come, the capital pool will come, who will look at your report. So you may have engaged a Khaitan or EY to do the diligence, and you set certain targets, but you're going to pension fund who may have a different risk appetite altogether. It will be counterproductive at that point in time to do a diligence at that point in time. So I think that's one, to see who are your consumer of business. Second is, again, transactions are evolving, and a number of times we are seeing in M&A deals, you have warranty and indemnity insurance being taken up. So when you're underwriting risk, a big part of your underwriting risk are the insurer providers. And when you involve insurer provider, it means another law firm will come who will review the targets or the buyer's review, and then are going to cut across what risk is livable or not livable. So I would say these are broad things that buyers should keep in mind. The other part is, of course, not sharing the vision or the goal objective very clearly. We have done so many of these transactions where it starts off by saying we're going to do a share deal, and during the process that your mind changes and you say let's do a business deal, an asset transfer, or a slump sale. Now if you've told your team to look a change of control provision because it's a control deal, and that moves to an asset deal where assignment provisions become very critical, you can't send them back. It's a time lost. So I would say sharing what possible situations could be, what is the transaction parameter could look like, briefing them, getting the right senior people and advice both at target and at the advisor level are the ones I would pick as 2-3 common big ticket items, and rest are all human process type of issues which very well aware of. I would say well covered in this group.
Thank you, Akash. I mean, that's a lot of planning, coordination, and focus needed for diligence. I mean, very clearly. So let's look at some of the tools for diligence, Kuldeep. Can you share with the audience some of the important and effective tools available to buyers in undertaking diligence? And how has the use of these tools changed in recent times?
My apologies. Sorry, I had gone on mute. Sorry. So I think from diligence inputs for diligence or diligence tools, information memorandum, the business model, management presentations, those are basic things that all of us are aware are the diligence tools that are used for the purposes of doing diligence. I'd like to add 2-3 things in addition to some of the matters that I just discussed. One is clearly the use of technology. I think use of technology has become very, very prevalent in due diligence these days, especially, and there I would say I divide that in automate and analytical. So there's a lot of tools that are currently available today. When you have a set of financial statements, suppose we're doing a diligence on a company which has got 20 subsidiaries and the business, so all of it can be consolidated automatically. Financial statement can be downloaded from Excel, consolidated. So those kind of tools are available today with us, which can help us become more efficient in terms of automating the entire process, which was earlier not the case. This transition has happened only in the last 3 years. The second is use of analytical tools like Power BI, and another one is Spotfire, which you use a lot in financial services companies and in retail consumer businesses, where you have a whole amount of data. So you have to do data analytics just to make sure that the data on which you are analyzing is correct and appropriate. So use of some of these analytical tools have also become very, very prevalent. Again, it has brought in more accuracy, it has brought more efficiency in the entire process. So one is the whole shift in technology that has happened, which has essentially made diligences become much more robust. Second is the use of expert. What I have actually seen during the course of the last 3 or 4 years is that stat firms, obviously they are business experts, but especially the financial sponsors, these days, whenever they do transaction, they basically have a industry expert available as an advisor from the very beginning of the engagement. So that industry expert then plays the role of advising the sponsor on the entire transaction, be it financial diligence, legal diligence, commercial diligence, any kind of diligence, because he is the person who spent a lot of time and months in the industry. So he's able to bring real value and synthesize all the diligence findings for the financial sponsor. That's another tool that we've recently seen being employed. And the third and most important thing from a diligence perspective as a tool is field visits. I can never overemphasize on this thing that unless you go and see a plant, unless you go and see a real estate project, unless you go and see and meet people on the distribution side, you will never be able to understand the business and appreciate the company. Just to give you an example, during COVID period, there was this pharma business that had grown significantly because the whole bunch of unorganized business had stopped, and the organized guy was able to get the benefit of that. At the end of COVID, around November, December, when our team went and met at the site, we actually found that a lot of volumes that had moved to the organized players had actually started to shift back to the organized sector, resulting in decreased realization as well as decreased volume. So going to the site or visiting the field, meeting the distributors, meeting the business folks is a very, very important aspect of any diligence that can give you a lot of insight, which you'll not be able to get otherwise. So those are the 3 or 4 additional diligence tools that we use and that typically everybody should use, so as to be able to be very insightful and meaningful for the purpose.
I mean, that is truly insightful. I can only share one experience which I encountered, where diligence was done on the basis of photos and videos, and the transaction closed on that basis. And very soon thereafter, there was a fraud case filed because all of those photos and videos were forged. And just shows exactly what you're saying, that nothing can replace actual visits. And we'll discuss a little bit on COVID times as we go along. So, Sharat, over to you. And you really get the reports and get to see the reports. You are the buyer of businesses today. How and when should diligence reporting be done to be effective? Can you share some of your thoughts?
So both I'm looking to my previous life and the current responsibility both. I believe that in any diligence there are three stages. One is the primary one, second is the detailed one, and one is the final. I think all three have a very clear purpose. As I always say that no M&A should be done without a strategic reason of doing it. So you clearly know why you are getting into. I think the first primary phase is the most important from that viewpoint. So you can identify the business risk, and clearly go no go decisions can be made here. In fact, this stage is where you clearly know what will make this deal go and what is this will make this deal not go. And those parameters need to be defined, and those also define your priorities as well as your decision making capability in the next stages. The second one is most critical, but it is very in a type it's very complete, where you talk about all aspect of external evaluation, physical visits, management decisions, tax, legal, all aspect of it. And that's where you confirm what is the right valuation for this company, and this is and your validation of certain aspect of hypothesis which you had in the primary phase. And the last part is the final one, where you make the close outstanding questions and obtain signed definitive agreements, and this is where the close and final pricing is done. And I believe all this need to be done in a from a very close, timely in a close, well-defined, close time manner. Actually speaking, if you keep it a long time distance between these three phases, the result can be really different. And just to repeat what Prasanjit highlighted in terms of planning aspect of the diligence, and second thing what Himanshu was talking about, the PMO aspect of it. And I think these are the two critical elements, which is very, very important, especially when you're doing a large transaction, because complexity is huge. And I think these three phases to me makes a important aspect. And let's not forget that while there's a team which has been set and communicating, and the client side should take the leadership and connect all the advisors together, because you have many different advisors coming who may not be knowing each other or may not have a chemistry also sometime. But the client responsibility goes there. But a lot of internal communication goes through. Which is very important, especially the internal stakeholder communication happens. So these three phases need to be seen also from internal reporting and getting the buying in internally also. So yeah, that's all from the reporting side from me.
Thank you. Thanks, Sharad. I know we are getting to the end. I have two questions before we get to the audience questions. I see some very interesting audience questions coming. PC and then Abha, I have two questions for you. Prasanjit, can you share some of the potential solutions for diligence issues which come up? Typical solutions.
Sure, Hegrim. I think the solutions would invariably depend on the nature of the problem, isn't it? I mean, ultimately, if it's a issue which can be resolved through, let's say, a condition precedent to the satisfaction of the buyer, it can be made a CP. If something which is a long drawn problem, but a really important one, then you have to look at some more colorful structures like escrow, holdbacks, which really will give adequate comfort to the buyer, and so that the buyer is not shortchanged in the process. Other issues could be structural options, could be your kind of deferment of purchase price or adjustment to the purchase price upfront, which is purchase price adjustment. Now, what could be those issues? The issues could be, let's say, the company, the target company had a significant license, which was really the driving force of the valuation. Now that license has expired and the company is carrying on the business on relying on an application which is still pending approval. The buyer may not be willing to take a punt whether this approval may or may not come, and while people are willing to close transactions, but then you will have to look at either an escrow mechanism or reduction in purchase price to get over this risk. Similarly, there could be other trivial issues which can be made condition subsequent. Not everything is a red flag, and that maturity one must have as a client as well as advisors to really weed out the critical issues from the non-critical issues. But to sum up the structures, because of want of time, you should have CPs, condition precedents, reps warranties, indemnities, which is the most commonplace solution. But bear in mind, indemnities needs to be enforced. So therefore, if it's a red flag critical issue, which goes at the heart of the valuation, I would say carefully look at escrows, holdbacks, and purchase price adjustment to adequately mitigate buyer's concerns. Thank you.
Thank you, Prasanjit. So we've got the lawyer's view. Now let's look at the banker's view, Abha. So how do you price or ascribe value to material risks and opportunities identified in diligence and reflect that in your deal pricing?
Yeah. No, so that's why I was smiling when PC was talking that most of these consequences are covered, but from to come to a solution, things which can be done as CP, I'm sure PC will be happy to take that as CP in any deal. But to get through the borderline, it's very important to, at least the framework I use is probability and impact. So the impact of any item on diligence could be either low probability, high probability, and high impact, low impact. So sometimes those high impact with medium to high probability probably is a deal breaker. So to give examples, in a consumer deal, if the IP is under question, that probably could be a deal breaker. In a education, hospital deal where we are dealing with human lives every day, anything on question mark on safety probably could be a deal breaker, but there's a high impact. I mean, probability doesn't matter. Whereas for anything else which are more mundane, which is say tax findings, etc., more often than not, basis probability, you will either adjust the price. I mean, and the probability is always a buyer versus seller perspective, right? Seller being in the business will always have more information and have a better view, but it's also biased view as a seller. And where again it matters whether it's a minority or majority deal, as Himanshu mentioned, because in a minority deal, you may have the buyer may have an indemnity of a certain amount, but the partner is in there with you with a larger stake. So so minority versus majority makes a big difference. But on this grid of low probability, high probability impact is where we find solutioning around whether it's a price adjustment, or sometimes when seller is very confident, we found deferred payment and call it even longer duration indemnity when the matter of the time period for resolution is longer, to be the solution for if the seller is not willing to take a price reduction. Things like some findings wherein the business model itself is questioned, I think there is no other way but to change the price. Like, taking from Kuldeep's point of view, I mean, if Kuldeep was to highlight that there is a certain change in regulation which makes the pricing, changes the pricing power, or changes the price escalation assumed for future is restricted, given what we've seen in the diligence, if some of those assumptions which you've made at the term sheet stage or while talking about a deal versus you find a significant difference while doing a diligence, those are the ones typically which gets into change in pricing. So any change in business model per se is a pricing change. Anything which is more probabilistic, buyer versus seller views differ. Either you take a probabilistic reduction in deal value and try and close the matter, typically in majority deals, or put it in the indemnity bucket, as PC was talking about.
Oh, thank you, Abha. Again, very insightful. So I think that brings us to some of our audience questions. And we've got some fantastic audience questions. So the first one, I think, is for Abha. How has COVID changed how buyer diligence is done? And will these changes be permanent?
So I think we've covered most of these points, in some form between Kuldeep, what Akash mentioned about team formation, etc. So the changes that we really saw was about how people were using technology because of the physical limitation around you not being there, right? But as we speak, we are seeing those revert, right? So anything which has a retail presence and needed those branch visits and, like Kuldeep said, go and meet the distributor kind of thing, those are coming full-fledged back because there is no shortcut to those. Then there was a fact about people and teams sitting together at client site and conducting diligence. There, I would say, in the last 3 or 4 years, anyways, we were seeing a change in that, right? DD team sitting there for 1 month versus team sitting out of their office for 2 weeks, working on intralinks, working on virtual data rooms, and last 1 week being spent in the client office. That gradual shift was anyways happening. In the COVID time, probably that last week was also done remotely, which I think will again revert back on being at the client side because it's kind of more efficient. So those are the changes which I think so to the point about it will mostly get reverted wherever people have learned or taken to tools doing things efficiently, which is not only in diligence, it's across our businesses. Some of those changes will remain, but the importance of physical visits in plants and retail businesses or sitting with the team for the last 1 week of diligence probably will revert.
Thank you. Thanks, Abha. Then I think we have the next question for you, Himanshu. How is diligence different from a buyer's perspective when the target involves a stressed asset? I think you're best placed to answer this. Whoever's thought of this question and pointed it to you knows exactly what
I hope we're not referring to any specific deals. No, when we talk about stress deals, I think, as I was saying, that very important to really understand the nature of assignment. And this is a comment to the client itself. So especially in stress deals, let's divide this into 2 parts. One is whatever happens through bankruptcy, and the other is pre-bankruptcy, there's stress at the promoter level or at the company level or whatever. There are 2 parts. Firstly, I would say generally I would be, I was very bullish about IBC process and all of that stuff, but the reality is when you start talking to RP and all of that stuff, I think the market has not become sophisticated enough for the RP to really understand what the buyer is looking for. So invariably you would not have the information that you're looking for. It's strange that when you try and even buy a real estate asset and you're asking for rent rolls, you're talking about NOI concept, you're talking about EBITDA concept, as in these things this is French to still most of the people who are running bankruptcy processes, right? So more often than not, lack of information is something that you have to live with, and the only way you can deal with that is by pricing that lack of information into your model, right? And then you really think through what comes through your, what are the quirks of bankruptcy laws in India that you have to live with, and so on and so forth. So during bankruptcy, always very difficult to really get to the information point that ideally that you would like to get to. So the only way is to really solve for through pricing. The good part is that you get protection otherwise under the code, so you don't feel terribly bad. The real critical one becomes when you are not going through bankruptcy. Let's say the promoter is in stress, or the opco is in stress, and you have only 10 days to do the deal. At that time, how do you really process the diligence to the extent possible? And to that one, I go back to my first comment that I made, that you don't have to look for 100 items. You straight away get to what Abha was saying, that even though it's a low probability item, all the high impact items, generally when you are in stress, the promoter is in stress, the opco is in stress, that there can be considerations for you to be fully aware of, whether on the financial side, whether it's on related party transactions, whether it's on the regulatory compliances, and so on and so forth. So you have to really pick the areas that can really affect the very sustainable, the model itself, or the very sustainability of the sustenance of the business, and really do that. Limited diligence can be done in 10 days, 14 days, but that's a diligence where you just look top down and have 5 items instead of 10 items. Get comfort with that, price in all the sort of risk, the other risk that you couldn't get to, and hope that you are able to solve the stress problem for the promoter or the opco.
Thank you, Himanshu. There is a question for you, Sharad, and I think really apt with what you've been doing. How should diligence be done differently for early stage or mid-sized startups? And what are the few important items for risk mitigation for such investments?
Yeah, I think it's a interesting and difficult question, honestly speaking, because a lot of things go through your feeling towards what you see rather than what has been written in the theory. So I think from my viewpoint, any business, you have to see a clear business proposition, and why you are doing that. Sorry, I'm repeating this, but it's very important for me to understand. You are doing it for the financial relationship or the interest, or you are doing it purely for your strategic relationship for the business you are doing into. And then if you are doing strategic, then very easy for you to see that there is a fitment there or not. But if you're doing purely for finance relationship, you want to see that you have a revenue multiplication. You have to be careful in understanding if this proposition is unique in nature, at what stage you are getting into. You have to understand who are the people. Is there a unique IP which they are selling, or is just if they are not selling unique IP, do they have any other benefit in terms of acquisition of customers or something which can make them ahead in the business? So it really varies. High grief. I will surely see it from a viewpoint of who are the founders, where they come from, what is the business value they have got into, what are their technical capabilities, the talent pool in the companies, and their ability to scale this business. I've seen 90% of them fails after doing first level of business activities. They're just not able to scale it, actually speaking, when their ability to manage success is very poor as compared to their ability to manage failure, which is very, very well done. So if you're able to identify this, and this is all going to happen through a lot of meetings and discussion, which I strongly recommend. And this is where COVID play a very, very, very difficult role. Actually, you may be doing a lot of assumptions through meetings, through virtually, But if you meet somebody in person, go to their office, understand what they are trying to do, it does give a very strong feeling. And this is specifically for startups. When there is no material activity or less material activity which you are investing upon, you need to get a feel of what they are trying to do and what they are trying to deliver in future. Because majority cases, startup, you are investing in futures, actually, not in the present. So I would suggest that meet more people, meet the founders, and evaluate the founders more importantly, not just the solution alone.
Thank you. I think we have two more from lots of questions from the audience, but we'll take two given shortage of time. So Kuldeep, one question for you. How are you seeing AI platforms being deployed in diligence? And do you think they will replace professionals in the long run?
Short answer, professionals cannot be replaced in the long run also with artificial intelligence. Yes, artificial intelligence usage has been increasing. As I mentioned earlier as well, there are now platforms that we use which help us automate the transition of the information, which help us analyze it better and efficient. But I think ultimately the human end, at the end of it, what is deal making? It's all about taking a call. It's all about forming a view on the business and the promoter, whether you want to invest. That particular view can only be as a M&A professional by the person who's making the deal, and also the advisors. At the end of the day, the M&A professional has advisors to give their view, right? And that view can only come in with your experience, with the fact that you've done that work, with the fact that you know this. So I don't think so AI can replace that forming a view on a particular situation or a matter.
Well, thank God for that.
It can supplement. It can supplement, but it can never replace. It can never replace, let's say, Himanshu making a deal or a Sharad saying yes or no. I have to do this.
So
As Sharad mentioned, very, very important. The human element is very, very important, right? The feel,
right.
the sense, not only of the business. If you just heard what Sharad said, it's about people. You're forming a view on the person first, and then the business.
Kuldeep, you'll never admit this publicly, but give us the real and honest answer now. That was a good.
If I can add to Kuldeep's point, I believe it is making the process efficient, but there is a manual interrogation which is very critical to the data too. It's very critical. So it is impossible to get people out, but definitely it's going to make the process more efficient and transparent.
So we have to take this a very important question. How are you dealing, Akash, with insider trading issues when you're dealing with listed targets?
Right. So I know we're pretty much at the fag end of the time, but this question is important. I think a number of situations where people are looking at it as listed or part of a conglomerate which has listed, securities, and information could be unpublished, price sensitive. And I don't want to, so there's a straightforward answer which is very process oriented. And that process oriented answer is that today our regulator has kind of created a sort of a manner or an architecture in which information can flow. So if you're dealing with a listed company, the board of the directors have to take a view whether the transaction is in the best interest of the company, based on which the company would sign NDAs and give access to a buyer and its advisors. And there's a record keeping process so that in future, if there is detailing required, the SEBI or the regulator has the handle to get that information on who access that information. So that's the easy part. The difficult part is, what is UPSI? What is this price sensitive information? What is material? And this debate over how windows should be closed. At what point in time a transaction becomes reportable? Who are the people who, there are certain people who are always in know of price sensitive information. And the question would be that, if I sign as a buyer a memorandum of understanding or term sheet which says non-binding, does my intent to acquire trigger at that point in time or later on? So I think there are a bunch of issues. I think we can have a full discussion around it, but I would say if your transaction, simplistically speaking, if your transaction triggers an open offer, in which case you don't have to go through a cleansing process of any unpublished information, because from a regulator standpoint, there's a parity in pricing. What you get from a buyer, negotiated trade buyer, it's what the public shareholders will also get. And in situations where you're not triggering an open offer, that is where you have to cleanse information. Either the information by itself becomes public, or 2 days prior to you announcing the deal, you have to find a way, as determined by the board of directors, in the manner that they determine, you make that information public and then you do the trade. So yes, in summary, it's a minefield. You have a personal liability, institutional risk, and you don't want to tread at all and come in the front pages of Mint or ET on any violations, and diligence becomes extremely critical in those situations.
Thank you for that capsule on a very complicated subject. Thank you, Akash. So I think that brings us to the end of our session. PC, before we formally end, can you sort of give some of the key takeaways out of this? I certainly have come back as a more capable, intelligent lawyer, I should say, in doing diligences.
No, thanks, Hegrev, and well, lots of incredibly useful points being made by our August, panelist here. It's a very difficult job to break it down in 2 or 3 key takeaways, but 3 broad takeaways, if I understand the gist of the discussion. Firstly is planning and scoping. I think as we have discussed, that's the common theme, to really plan it out very well, to see who are the right set of people you want to involve in the diligence, lay out the scope, keep a track on the scope throughout the time the diligence is completed, because that plan can change as the structure changes and as the facts changes. So therefore, planning is absolutely vital. Second is diligence reporting. Not only the final report I'm talking about, it's the timely communication. As and when fundamental issues are unearthed, pick it up and escalate to the right personnel on a real-time basis. That is how you will get the most out for diligence exercise. And the report should be in alignment with the requirements. If the client doesn't want to read a 1000-page report, make an issue-based report which is digestible. Back it up with a presentation to the board so you can articulate the issues in a jargon-free manner. I know it's come as a shock to many in the audience. Lawyers are known for jargons and they think it's all very fancy. Believe me, that doesn't help at all. Make it bereft of jargons. And last point is, how do you resolve the issues? Isn't it? It's fine to identify issues, it's fine to identify problems. Where is the solution? Solution lies in the nature of the problem. Is it a genuine red flag issue? Does it impact the pricing? Does it impact the deal fundamentals? If yes, look at solutions. It's very easy to call off a deal, but what are the solutions? And that is what a seasoned lawyer can do. Set up escrow, suggest a holdback, set up a purchase price adjustment mechanism, or have robust set of indemnities which can be enforced in light of the governing law which parties have elected into. And that would be the 3 key takeaways, I would say: planning, scoping, diligence, reporting, and how to resolve. Over to you, Hegrev.
Thank you. Thanks for that great summary, PC. Very insightful. So before closing, I just ask each one of you in the audience to respond to the poll slide on your screen. Provide your feedback in today's webinar. We take this very seriously as part of our continuous improvement program. And finally, I'd like to thank each one of our guests for sharing the experience and expertise with us today. Abha, Himanshu, Sharad, and Kuldeep, thank you very much. Without you, this webinar would not have been possible. You each did an outstanding job, and we are very much indebted to you. To our audience, I hope you found the webinar interesting and a worthwhile investment of your time. We certainly enjoyed bringing it to you. After the webinar, we will send you a copy of today's presentation materials and a link to the webinar recording. You will also separately receive a request for your feedback. Please do take time to send us your feedback, criticism, comments, and even compliments. The form will take less than a minute to complete. And please do not hesitate to contact us for any issues arising out of the webinar. Our details are below. And thank you again to our audience, and look forward to being of service again for future webinars. Thank you.
Thank you very much.
Thank you, everyone.
Thank you.
Thanks. Cheers.
Thank you, everyone.
Thanks very much, everyone.